all these different indicia of intent can result in a finding of actual intent and therefore a fraudulent transfer. So from state to state, this varies a little bit, although these laws are fairly uniform. There are about 15 different badges of fraud, and you can find them in your materials. And the creditor's job would be to prove as many of these badges of fraud as they can. Right? They have to build their prima facie case. And the debtor will try to rebut those badges of fraud. They will try to argue that, well, no, despite the fact that I transferred the home to a family member after I got sued, my intent had nothing to do with my creditor. Well, how do we prove that? Well, Your Honor, a couple months before I got into the car accident that generated this lawsuit, I reached an agreement with my family member to transfer the home to him. This predates the accident, and if it predates the accident, my intent could not have possibly had anything to do with avoiding creditor claims. Right? So you make arguments of that nature, or you say, well, you know, yes, I was involved in a car accident, or yes, I was sued by a bank for defaulting on a personal guarantee, or by U.S. Customs for, you know, not paying my anti-dumping penalties or what have you. But just because I was sued doesn't mean that life comes to a stop. Right? You still have to continue to pursue your affairs, take care of your affairs. So people still engage in estate planning. Businesses still reorganize and reform and change their operations and business structures. And we still engage in tax planning and estate tax planning and succession planning. Right? So life goes on. So the debtor will try to prove that there is some business purpose behind the transfer, something that is not related to asset protection. For the creditor, this is not an easy argument to make because the creditor has to prove not that asset protection planning was contemplated. They have to prove that asset protection planning was the primary purpose behind the transfer. Primary purpose. Of first importance, right? And then that's not easy to prove. Right? So the debtor can say, yeah, I was aware of the fact that by transferring the home into whatever structure I was getting asset protection. I wanted that benefit, but that's not really what motivated me to pursue that. The second type of a fraudulent transfer are transfers involving constructive fraud. Constructive fraud, under this test, we do not care what intent is. We just don't. It does not matter what intent is. Under this test, there are two numbers we look at. Was this a transfer for a fair market value? And was the debtor insolvent at the time of the transfer or as a result of the transfer? Intent is completely irrelevant. If the creditor can prove that the transfer was both for less than fair market value and the debtor was insolvent or became insolvent as a result of the transfer, you have a fraudulent transfer. And obviously, for a plaintiff, this is much easier to prove because it's just a straight numbers game here. So if we are concerned that the plaintiff will try to argue that whatever it is we did is a fraudulent transfer, we have to make sure that we are transferring clients' assets for fair market value so we can knock out the constructive fraud argument. And if we are engaging in the transfer of assets for fair market value, we are also knocking out the most important badge of fraud. Transfers for less than fair market value make it a lot easier for a plaintiff to prove a fraudulent transfer. So now on to the most important point of the presentation. What does it all mean? What does it come down to, the law of fraudulent transfers? First, let's take a look at it from a client's point of view, and then we'll look at it from a lawyer's point of view. From a client's point of view, what choices does he have? I'll give you another recent example. My client was, well, she's still alive, she's 74 years old at the time this happened a few years ago, and her son decided to become a real estate developer. He borrowed something like $5 million from the bank, and mommy signed the personal guarantee on the loan. 3 years later, all of the son's real estate projects are upside down. He walks away. Mommy is sitting there holding the $5 million guarantee that will completely wipe her out, and she'll be left with nothing but her Social Security check. So what options does she have? It's a binary choice, right? She can choose A, to do nothing, which has the advantage of being really easy to implement and fairly inexpensive upfront. And if she chooses to do nothing and the bank gets a judgment against her, what are the odds that she will lose everything that she has? Something around 100%, give or take 0. So that's option A. Option B, she chooses to do something to protect her assets. And if she chooses to do something to protect her assets, the bank may challenge that as a fraudulent transfer. And if they challenge it as a fraudulent transfer, they may be successful. And even if they are successful, what will happen? Well, what is the remedy for a fraudulent transfer? I guess is the right question. The remedy is to unwind the transfer. So the worst that can happen is that she is returned to her starting position. So to her, what is the downside of trying? In her case, even the legal fees are not a downside because she would have lost everything anyway. So we're just reallocating a portion of that money to a better use, in my opinion. But does that mean that we as lawyers can assist clients in engaging in fraudulent transfers? Obviously not, right? So if we have a fairly good idea that what we're doing would be a fraudulent transfer, we can do that. Our ethics rules prohibit that, maybe personal ethics as well. Problem is that very, very often we do not know that something is a fraudulent transfer until a trier of fact determines it to be a fraudulent transfer. Right? Something is not a fraudulent transfer per se, right? It's a judgment call by a judge. And a fraudulent transfer does not make the transfer void ab initio. It makes it voidable, right? So the creditor must bring a fraudulent transfer argument and then must prove it. Without it, there is no fraudulent transfer, right? So up front, when we do this work and the client comes to us with their story, which may or may not be true, do we know whether we will be engaging in a fraudulent transfer? The answer is very rarely. Very rarely. So very often it's an examination. Very often it's an examination of, what is the likelihood of a successful fraudulent transfer attack? What can we do to minimize that challenge? What can we do to make the plaintiff's job more difficult? And if you conclude that, there is a high risk here that the plaintiff will bring a successful fraudulent transfer attack, then maybe you as a lawyer should not be taking on that case. Because there is, for the lawyer, there is liability exposure. For the lawyer, there is liability exposure because there are cases where lawyers have been sued for aiding and abetting in a fraudulent transfer. It's an extremely difficult case to prove, extremely difficult. There have been some instances where plaintiffs have tried that with us, never successfully. But whenever that happens, as you can imagine, it's quite a headache, right? It's a lot of stress for you. It's something you need to deal with. It will take money almost always to settle the case. And most importantly, these cases are not covered by your malpractice insurance because aiding and abetting in the fraudulent transfer is not an act of negligence, right? So you will have to come out of pocket. So lawyers need to be really careful when they do asset protection work and trying to figure out which clients they should take and which clients they should turn away. We probably turn away a good 30% of the clients that come in through the door. So you need to be very, very critical of when you do this work and sort of self-aware of the risks you are taking. And you need to have the stomach to take on these risks. And this is the reason why asset protection planning is still sort of a small practice area. There are very few people that practice it. When I started practicing it, which was about 15 years ago, there were 10, 15 guys across the country that did this on a full-time basis and did it well. Now there may be 30 guys across the country who do this well and do this on a full-time basis, and a couple hundred other people, who claim that they are asset protection lawyers. So still very, very few people because most lawyers do not have the stomach to take on these risks. This is why you do not see the big law firms practicing asset protection. Okay. As I mentioned, if you do have questions on anything I'm covering, it's a fairly short presentation we have today, so I won't be able to get into everything. You're welcome to email me the questions. You have my email address, or you can post them in the Q&A box, and I will answer your questions at the conclusion of the presentation, which is in about 40 minutes. So now I want to move on to the actual structures. And given that we're talking about protecting business assets, let's talk about asset protection that is sort of unique to a business. People very often associate asset protection planning with planning for individuals. And truth be told, the vast majority of the time when we are engaging in asset protection planning, it is for an individual, because this is where the client has the greatest concern. Right? Everyone wants to keep their personal residence. They don't want to have to pack and move out and send their kids to a new school. They want to keep their residence. They want to keep their retirement accounts. They want to keep their savings and what have you. Business assets maybe are a little bit less personal. But for a client for whom their business is a significant portion of their net worth, or if the business has significant assets, protecting those business assets are just as important. And, we've done a lot of work in this arena. Sometimes it's protecting assets of a going concern. So, for example, with U.S. Customs, our client was a very viable, very successful business, operates across the country, millions upon millions of dollars in assets and intellectual property. They wanted to continue to operate the business, but the $10+ million customs assessment would have probably put them near bankruptcy. So they want to preserve the assets of the business. They want to maybe settle with the creditor and get back to work. I have represented clients against the SEC, the FTC, the FDA, the IRS, the state agencies, local agencies, but primarily against private creditors. Right? The primary thrust of the work when you do asset protection is to protect assets against private creditors. So the client is being sued by a competitor. Very frequently over the past probably 7-8 years, we are seeing our clients being sued by their employees. Often these are class action wage and hour type lawsuits that some plaintiff's attorney is filing. These may be lawsuits for violating some sort of worker compensation laws. These may be lawsuits for deceitful billing practices for a medical office. And there's like a whole multitude, right, of cases, breach of contract cases and what have you. So is there a distinction between an individual being sued and a business entity being sued? I think there is a distinction. There are several distinctions. First of all, there is a distinction as to the types of assets that we will commonly find that an individual owns versus an entity. So an individual is concerned about protecting his residence, his retirement accounts, and his liquid assets, and maybe rental real estate, right? That's kind of the most typical tax pattern. Whereas a business entity mostly is concerned about protecting accounts receivable, intellectual property, and inventory. Maybe some businesses have equipment and what have you, but primarily it's accounts receivable, inventory, and intellectual property. So if your client has a business that has those assets, how do we keep them safe if the business entity itself is being sued? Well, first of all, does it matter what is the nature of the entity being sued? A corporation or, let's say, a limited liability company. If the entity is being sued, then it really doesn't matter what kind of an entity it is. Corporation, LLC, partnership, trust, individual, whoever is being sued, once the plaintiff gets a judgment, they will be able to get at the assets owned by the person who is being sued. So it does not make a lick of difference as to the nature of the entity being sued. Where the nature of the entity does create a distinction is when the plaintiff, following a lawsuit against the entity, will try to pierce the corporate veil of the entity and go after the assets of the individual owners. Here, the entity distinctions are important. So if our client operates his business through a corporation and there is a lawsuit against the corporation, the question is, can that plaintiff go after the personal assets of the shareholders? And the general answer, and you should remember this from first year of law school probably, the general answer is no. The corporation gives us the so-called liability shield. Now, why does the corporation give us a liability shield? The corporation gives us a liability shield because the corporation is the one being sued. It's a separate legal person, has its own juridical existence. And once the plaintiff gets a judgment, with that judgment, they can take only the assets of the corporation and not someone else's assets. And the assets of the shareholder are someone else's assets. The exception to this rule is the concept of piercing the corporate veil, where under certain circumstances, the plaintiff can set aside the corporate veil and proceed against the personal assets of the shareholder. And they can pierce the corporate veil if there is commingling, meaning that corporate assets are used for the personal needs of the shareholder, or the corporation is not observing and not maintaining formalities, the annual meetings, minutes, filing tax returns, filing Secretary of State registration forms, and so forth. With a limited liability company, do we have the same analysis or a different analysis? Well, to a large extent, it's the same analysis. If an LLC is being sued, it is a separate legal person. And unlike with a corporation, with an LLC, there's usually a state statute that says that LLC members are not personally liable for the debts of the LLC. That maybe actually is even a stronger protection than the corporate common law that holds shareholders not liable. But where the major distinction is the grounds under which the plaintiff can pierce the corporate veil of an LLC. LLCs do not have any sort of formality requirements. LLCs are not required to maintain those annual meetings and minutes. They have a lot less formality to them than a corporation, which means we're taking a big argument away from the plaintiff in their ability to pierce the corporate veil. And really the only way to pierce the corporate veil of an LLC is for commingling. Right? So a more difficult entity to pierce, so LLCs from this standpoint are preferable. But let's say that we do have a business entity, corporation, LLC, whatever else, that owns, that has money in the bank. Let's make it simple. It has a bank account with $10,000 in it. Does it matter what type of entity we're talking about as far as the creditor's ability to reach the $10,000 in the bank account? And the answer is, it does not. They will get a judgment against the entity, and they will go after the entity's ass. And it does not matter what type of an entity we are talking about. What could matter is the fact that the entity is overseas. If the entity is in the United States, regardless of the state that it's in, even if it's in a state different than the one we are in, the one that the plaintiff is in, under the full faith and credit clause, plaintiff would be able to go after an entity anywhere in the United States that has assets anywhere in the United States. But let's say that the entity we're talking about is a foreign entity that has assets overseas. Now the plaintiff's job is more difficult. The plaintiff's job is more difficult because, first of all, if you have a foreign entity, access to information may be very limited, right? We don't know what sort of public information is available in Angola for an entity you may have there. I actually don't know if Angola has entities or just gorillas in the jungle, but different jurisdictions have different rules and different transparencies for fiscal entities, different information that is publicly available. For the most part, regardless of where in the world you are, the transparencies of entities will be the same as in the United States. These laws are fairly similar from country to country. Certainly, like let's say in the British Commonwealth jurisdictions, 30 or so countries, these laws would be very similar to the United States. But there are some distinctions. So, for example, let's say that our client is operating his business and somewhere in that corporate structure, there is a Delaware LLC. When we form a Delaware LLC, Delaware does not require us to identify the manager of the LLC. It's one of the few jurisdictions in the world, I think the only one, well, it's not the only one in the United States, but there are, I think, one or two other states that allow this. But the United States is the only country that has jurisdictions within it that allow entities to be formed on an anonymous basis. Don't believe that it exists anywhere else in the world. So if the plaintiff comes up against the Delaware LLC, they may have a difficult time figuring out what is this LLC, who owns it, trying to find its assets. And I'll tell you, when we do business structuring and tax structuring work for our foreign clients, we use Delaware LLCs a lot to gain these foreign clients a degree of privacy that they want for their assets, for their holdings. But generally speaking, if we have a foreign entity, it is more difficult to get information. You cannot subpoena information from a foreign, let's say, registrar of companies or foreign persons, because they're not subject to the jurisdiction of a U.S. court. And once the information flow stops, the plaintiff's job in collecting on a judgment becomes exponentially more difficult. So foreign entities are certainly helpful to us in the world of asset protection. How else are entities helpful when there is a business lawsuit? Well, if a business entity is being sued, let's say that one of the assets that our business entity has is an investment in a limited partnership. Right? Maybe this business entity is holding some shares in a limited partnership, and this limited partnership is an oil and gas deal in Texas. So the question is, can the plaintiff of the business take from it the interest in this oil and gas deal? Well, the answer is, the general answer is no, they cannot do that. The plaintiff is not allowed to attach an interest in a limited partnership or an interest in a limited liability company. The reason for that is state law. Under state law, there's simply no such remedy available. With respect to interest in limited partnerships and LLCs, the plaintiff is limited to what is known as a charging order. That's the only remedy they can pursue, with some exceptions, like, in some exceptional cases, they may be able to get a receiver appointed over the entity. But outside of receivership, which is a fairly rare remedy, the charging order is the only remedy. The charging order basically allows the creditor to attach cash distributions out of the entity. And if our client controls the entity, he can stop making distributions and the creditor gets nothing. So generally, interest in LLCs and limited partnerships are not that desirable for creditors to pursue, because the charging order is not going to be, in most cases, a very productive remedy for them, with the exception of this Texas oil and gas deal. Why? Because this Texas oil and gas deal is not being run by our client, right? There's some promoter out there, probably in Texas, who's running this limited partnership. And this promoter in this limited partnership has 1,000 investors. To protect our client from a charging order attack, the promoter would have to stop making distributions to all of the limited partners. That's the only way they can stop making distributions to our client. And obviously, they are not going to do that. They're not going to do that. They will continue to make distributions to everyone, including to our client, and the creditor can then attach the distribution that our client receives with their charging order. So for this charging order limitation to work, our clients must own their assets through LLCs and limited partnerships that they control, where they have the ability to turn off the distribution. And this applies to legal entities that our clients have. Our client has a business that's, let's say, a corporation, and this corporation is being sued by a plaintiff, and the corporation owns inventory. But it owns inventory not directly, but through a single-member LLC. Well, the plaintiff may actually have a difficult job getting at that inventory, even though the corporation is the sole owner of that LLC. And so something for you to consider. Moving on. This is really a really important point for business asset protection. So let's say that we have a client. Let's see, I had a client recently where we did this for them. Oh, so I have a client who is in the business of distributing flooring materials. Very, very large business, and there is a significant lawsuit against the client right now. So this business has what kind of assets? Well, this business owns some very, very valuable intellectual property like domain names, trademarks, and things like that. This business has a lot of inventory. This business has a lot of contracts in place for supplying flooring materials. They're a distributor. And this business has a lot of accounts receivable. So when the lawsuit hits this business that my client has, which is actually also a corporation, which assets of the business can the lawsuit reach? And the answer is it can reach all of the assets of this business. Right? Once there is a judgment against this corporation, whatever